Johnson is going to be here at about 10 after the hour, but I want to thank Senator Johnson for co-leading this roundtable, and he was also involved in the one that we had a couple weeks ago. I hope the public understands that Republicans are in the minority, so we can't hold formal committee hearings because only chairmen of committees, which are Democrats, call those hearings. So these oversight roundtables are an important part of the investigation that we do through our respective offices. And Senator Johnson and I have a great deal of working cooperation for a lot of our investigations. And also for you people that have taken time out of your busy schedule to be here as panelists, I want to thank you for doing that. Three of our witnesses today are what we classify in an official way as whistleblowers. They happen to be Mark Jones, Mike Taylor, and Fred Wynn. They're patriots, and as I often have said about whistleblowers, too often by our bureaucracy, whether it's these three people or other people, because I've been dealing with this for decades, bureaucracy tends to treat whistleblowers like skunks at a picnic. Today we're going to discuss issues of very significant importance. Public safety is a connection. First, thank you, Senator Johnson. I just told him you weren't going to get here until 4:10. You're pretty fast. Okay, yeah. First, the government's failure to follow the law. And second, retaliation against whistleblowers who alerted the government to those failures. DNA Fingerprint Act of 2005 requires a federal law enforcement people and their agencies to do several things. Law enforcement agencies are required to collect DNA from individuals who are arrested, facing criminal charges, or are convicted, and from certain detained non-citizens at our border. These DNA samples are sent to the FBI database to assist and develop criminal investigations and leads for law enforcement. For many years, the Department of Homeland Security and Customs and Border Protection have failed to follow the law. According to recent protected disclosures by these brave whistleblowers with us today, in fiscal year 2023, DHS and Border Patrol only collected DNA from 30 to 40% of the 3 2/10 million individuals at the southern border. Even more concerning, according to protected disclosures, there are locations at our southern border in which the required DNA collection isn't even happening. Now, my oversight of these issues goes back at least 6 years. November 2018, I wrote a letter to DHS regarding that department's failure to collect DNA as required by law. In 2020, the Trump administration made regulatory changes and required DNA collection take place as the law demands. However, according to protected disclosures, federal bureaucrats put up roadblocks at each turn. Then the Biden-Harris administration assumed power. They simply stopped pushing the full compliance and failed to follow the law. Their non-compliance continues today. In 2023, after receiving new whistleblower disclosures, I wrote a letter to the same Department of Homeland Security. My letter included very precise, internal government data that clearly showed the Biden-Harris administration's failure to follow the law. The records also included FBI records that showed examples of illegal migrants who were connected to criminal cold cases after obtaining their DNA. The crimes included homicide, burglary, assault on federal officials, and sexual assault of minors. Those records illustrate the importance, very importance, of obtaining DNA at the border. The Biden-Harris administration, Department of Homeland Security, has failed to respond to my letter. On February 26 this year, I wrote to DHS highlighting the department's failure to respond to my November 2023 letter and requested an immediate response. My letter again made public brand new whistleblower disclosures regarding Border Patrol's alarmingly low percentage of DNA samples at our border. Again, I asked questions related to the department's DNA collection practices. Now, to date, which should be no surprise, the Biden-Harris administration's Department of Homeland Security has again failed to respond. The failure to collect DNA has real-life implications. We need to know who's coming to the United States. We need to know whether they're connected to any crimes. In other words, are they dangerous to our community? This is not a free-for-all. The Office of Special Counsel even performed a review of these whistleblowers' protected disclosures. That review said, in part, quote, CBP has failed to fulfill its responsibilities under the law and in so doing has compromised public safety. The failure to collect DNA clearly inhibits law enforcement's ability to solve cold cases and to bring violent criminals to justice. End of that quote. But I want to further quote the Office of Special Counsel. This office said, quote, the agency's noncompliance with the law has allowed subjects subsequently accused of violent crimes, including homicide and sexual assault, to elude detection even when detained multiple times by Customs and Border Protection or Immigration and Custom Enforcement. This is an unacceptable dereliction of the agency's law enforcement mandate, end of quote. Well, take a look and study that. An independent third party substantiates these allegations. After making their protected disclosures, all three whistleblowers were retaliated against, retaliation that's been extensive and enduring. From February 2018 through the present, DHS officials have subjected these whistleblowers to significant changes in duties, responsibilities, and working conditions. They suffered an overall reduction in pay, and they have been removed from their supervisory positions. These illegal actions by the government have negatively impacted promotional opportunities. For example, the Office of Special Counsel identified an intentional non-promotion for Mr. Jones. Additionally, in 2022, the Biden-Harris administration, Border Patrol removed credentials, law enforcement authorities, and firearms from Mr. Taylor and Mr. Jones. This resulted in Mr. Taylor losing his law enforcement retirement benefits after 30 years of federal service. The removal of one's firearm and credentials is the ultimate act of personal and career retaliation. The way DHS has treated these three courageous men is an absolute scandal. The Office of Special Counsel said its investigation supports a conclusion that the government's actions against these three whistleblowers constituted prohibited personnel practices. More recently, Mr. Jones was subject to continued retaliation by the Biden administration. Specifically, Mr. Jones and others within his office were asked to move to a different workplace. When Mr. Jones arrived at his new workstation, he was the only employee without connectivity, power, or phone access at his workstation, which lasted for over 3 weeks. Secretary Mayorkas has failed to cure the illegal actions against these three whistleblowers, and for me to put this as plainly as I can, the government has violated federal law, retaliated against three brave whistleblowers, and continued to refuse to take corrective action. It's a complete disgrace. The supervisors need to be held accountable. This senator won't stop fighting for these whistleblowers. My investigative efforts in this matter will continue. Now I turn to my friend, Senator Johnson.
Well, thank you, Senator Grassley. And again, I want to thank you and your staff's dedication over many, many years of championing whistleblower protections and actually protecting whistleblowers. And the result of that, just so the public understands, is whistleblowers feel very comfortable coming to Senator Grassley's office, and the public is made aware of things that the public deserves to know because of his efforts. Yeah, I certainly want to thank the whistleblowers testifying here today. A couple of weeks ago, we held a roundtable with additional whistleblowers that described how the federal government, HHS, knowingly is rushing, passing, and transferring unaccompanied children to supposedly sponsors who are undocumented, who the government knows full well are probably, in many cases, part of a transnational criminal organization that traffics humans, sex trafficking. And they're doing that because one of the whistleblowers was reported saying is the federal government doesn't get sued by traffickers. They just get sued if they hold on to these children too long because of the Florida settlement. So today's roundtable is talking about how the federal government is not following the law in terms of collecting DNA samples on people coming to this country illegally. Now, there's a couple reasons that we would want to do that. And the obvious ones are we want to try and catch criminals if we know about them to prevent crime. It certainly helps us solve crimes because we have these fabulous databases now. Once you get the DNA sample, you can match that with other DNA taking part of the crime. Again, to catch that criminal, to solve the crime so it doesn't create more crimes. My involvement as Chairman of Homeland Security in terms of DNA testing involved more of what has sparked all these crises now at our border, this flood of people. And I just want to quick tell the story, if you can indulge me a little bit, because most people don't understand why we have these crises. It really all began, the catalyst was the Deferred Action on Childhood Arrivals. That was the improper use of prosecutorial discretion, deciding not to prosecute hundreds of thousands of people who came to this country illegally. Children. The result of that is the human traffickers were able to communicate in Central America and elsewhere around the world that American immigration law has changed. And if you get into America now, you're going to be handed a white slip. They call it a permiso. That's not what it was. It was a notice to appear. But the reality of the situation is people started flooding this country. And I think it's 2014, President Obama declared a humanitarian crisis when we were encountering 2,000 people a day. Jay Johnson said it was a really bad day for CBP. It was 1,000 a day. Well, under the Biden administration, we've had December 10,000 a day average. One day, 14,000. But to get back to my story, President Obama, with his humanitarian crisis, started detaining families with their children. He was sued, and there was a court decision that reinterpreted the Flores decision, the Flores settlement, that required DHS to turn over, find a sponsor, no longer detain unaccompanied children after 20 days. And the reinterpretation of that said that included children accompanied by their parents. And so the Obama administration was put in a very untenable position of saying, well, if we want to detain the parents who have come to this country illegally, we still have to turn the children over to foster care, start separating families, which the Obama administration understandably and justifiably didn't want to do. So what that resulted in is fake families. We had testimony in the committee room, the Homeland Security Committee room in June of 2019, that they were selling children. We had a 51-year-old illegal immigrant confess that he actually bought a infant boy for $84 to have a fake family so he could exploit our asylum laws under that Flores reinterpretation. So that now you come in with a child, the family units were allowed in this country. And that is what has sparked these massive waves of illegal immigration. And so the fact that DHS just refuses it, and here's the real question I'm going to have, is why do career DHS personnel refuse to do what Eric Holder said was going to do after a year of just getting their act together, to do DNA testing to make sure that these actually are family units and not trafficked children? Again, it just boggles my mind. So again, I'll end now. I've rambled on for really far too long. But again, I can't tell you how much I appreciate your dogged determination to, first of all, protect whistleblowers, but also do the oversight in these areas that just lead to untold human depredation, untold human suffering that our federal government is turning a blind eye towards. So again, I just commend you, Senator Grassley, and the whistleblowers for coming forward. The American public needs to understand this so that we can stop it. Because there's just all kinds of horrible things, inhumane things happening to human beings because our federal government refuses to acknowledge the truth. So thanks, Senator Grassley.
Thank you, Senator Johnson. We cooperate on so many things, and this is just a small part of our cooperation. Now I'm going to introduce our witnesses. Fred Wynn is a federal employee for 25 years. He currently works for U.S. Customs and Border Protection, has been a part of the Department of Homeland Security for 13 years. He previously served as an operations manager in the Weapons of Mass Destruction Division. Prior to joining CBP, Mr. Wynn spent 12 years at the Department of Education. Mike Taylor is a federal employee with 31 years of federal service. He currently works at U.S. Customs and Border Protection and has worked the Department of Homeland Security 21 years since the inception of the department, going back to March 2003. He previously served as Deputy Director of Weapons of Mass Destruction Division in Border Patrol. Prior to his start at DHS, Mr. Taylor worked at the U.S. Customs Service, which became Customs and Border Patrol. Mark Jones is a federal employee with 20 years of federal service. He currently works at the U.S. Customs and Border Protection and has been part of the Department of Homeland Security for 12 years. He previously served as the acting director and branch chief of the Weapons of Mass Destruction Division at Customs Border Protection. He also served the Office of Anti-Terrorism at CBP. Prior to joining CBP, Mr. Jones served 8 years with the Federal Bureau of Investigation. Kumar Kimball is a former federal employee with the Department of Homeland Security. He previously served as Deputy Assistant Secretary and Deputy Director of U.S. Immigration and Customs Enforcement. Mr. Kibbe is a West Point graduate and served with the 82nd Airborne Division. I thank all of you for beginning, and we'll go from my left to my right. So would you start out, please, sir?
Senator Grassley and Senator Johnson, thank you for the opportunity to sit before you and your colleagues to answer questions regarding my experience as a whistleblower, the critical importance of the DNA Fingerprint Act of 2005, and the requirement for DHS to comply fully with this law. Senator Grassley, I want to thank you and your oversight unit for nearly 6 years of work to uncover and make public the retaliation against myself and my colleagues, as well as your efforts to hold DHS and CBP accountable for their duty to follow the law and keep Americans safe. My name is Fred Wynn, and I'm joined by my colleagues Mark Jones and Mike Taylor. Mark, Mike, and I were all part of the Weapons of Mass Destruction Division that was housed within CBP's Office of Intelligence. Based on our experience, expertise, and success in assisting the Department of Defense with running latent fingerprints on improvised explosive devices against CBP's fingerprint database, we were asked to develop and implement a DNA collection pilot program. During this process, we identified the DNA Fingerprint Act of 2005, which requires DNA to be taken from all subjects arrested by federal agencies. Our pilot program was to bring CBP into compliance with the law and submit DNA samples to the FBI's Combined Index DNA System database. Significantly, collection of DNA at and between U.S. ports of entry allows our law enforcement community to develop investigative leads and solve cold cases throughout the United States. The low percentage of DNA collection that we see today allows criminals to commit further crimes, including forcible sex offenses, murders, trafficking, drug smuggling, and other acts perpetrated on U.S. citizens and residents. Given the enormous potential of DNA collection to solve cold cases and assist criminal investigations nationwide, we took our jobs seriously to bring CBP into full compliance with the law. We found that the career bureaucrats tasked with implementing this law were failing to make even minimal DNA collections. In May of 2017, DHS Secretary John Kelly issued a memorandum directing DHS components to enhance biometric collection practices in support of DHS's screening and vetting activities. CBP made no effort to begin DNA collection in response to this memorandum. In February of 2018, after DHS leadership became aware of the noncompliance with the law, a series of retaliatory actions, which Mr. Jones will outline, began. Full compliance with the DNA Fingerprint Act of 2005 is a crucial component of our nation's security efforts. The continued failure to implement the law must cease. Thank you.
Senator Grassley and Senator Johnson, thank you for the opportunity to come before this roundtable and answer questions regarding the DNA Fingerprint Act and the retaliation that has been taken against me and my colleagues. Senator Grassley, I specifically would like to thank you for the work that you and your oversight unit have done on this issue. My name is Michael Taylor. I am an employee at CBP and was part of the WMD division with Mark and Fred, as Mr. Wynn just noted. I would like to take a few minutes to discuss what I have witnessed from 2017 until the present as it relates to CBP's nonconformity with the DNA Fingerprint Act of 2005. As Mr. Wynn has just mentioned, we were directed to develop a DNA collection program that would ensure CBP's 100% compliance with the DNA Fingerprint Act. In 2018, as we were developing and close to implementing the DNA collection pilot program, we began to see that federal bureaucrats in charge of implementing the DNA Fingerprint Act were actively obstructing the law. Although I cannot speak to their motives, it became clear that certain senior officials were hell-bent on slow-rolling any process or pilot program that enabled DNA collection. While CBP ostensibly supported our development of a collection program, we were excoriated when the White House and the Department of Justice were made aware of CBP's and DHS's ongoing failure to comply with the law. CBP officials became further enraged with us when the White House and the DOJ were informed of CBP's and DHS's intentions to never comply with the DNA Fingerprint Act. CBP has maintained this defiant posture to this day. CBP and DHS sophistically asserted that a 2010 exemption absolved them of any obligation to collect DNA for nearly a decade. In a letter to President Trump, the Office of Special Counsel refuted CBP's fabricated assertion and chastised the agency for its misconduct and inexcusable failure to implement the DNA Fingerprint Act. The Trump administration published a final rule in March 2020 in the Federal Register that restored the Attorney General's plenary legal authority to authorize and direct all federal agencies, including the Department of Homeland Security, to collect DNA samples from non-United States persons who are detained under the authority of the United States. Any contrived notion of the existence of a waiver for DHS was ended on that day. Despite DHS and CBP internal directives and correspondence going back to 2020 and ordering compliance with the DNA Fingerprint Act, the FBI reported that CBP had a DNA collection rate of 38.7% in fiscal year 2023. That means out of approximately 3.2 million nationwide encounters, almost 2 million individuals did not have their DNA collected. The DNA samples that DHS and CBP did collect in fiscal year 2023 led to 1,037 matches in the FBI's combined DNA index system. Since these results are believed to be statistically linear, DHS potentially missed well over 1,600 criminals in fiscal year 2023 alone. It has been over 4 years since any perceived or imagined ambiguity has been removed from the federal government's law enforcement DNA collection requirements. Collecting DNA as required by the law is clearly not a priority for the current administration. Instead of taking the necessary steps to fully comply with the DNA Fingerprint Act, current DHS and CBP management seem more interested in focusing their efforts on continually retaliating against my colleagues and me for disclosing what can now only be described as their chronic malfeasance. Thank you. I look forward to answering any questions that you may have.
Senator Grassley and Senator Johnson, thank you for the opportunity to come before this roundtable. Senator Grassley, I would like to echo my colleagues have said about your oversight. Thank you for the work you are doing and to right the wrongs. My name is Mark Jones, former acting director of the Weapons of Mass Destruction Division. I had the honor of leading the WMD division and working on the DNA collection pilot program with Mike and Fred. I plan to speak to you today about the ongoing retaliation against me, Mike, and Fred as a result of our protected disclosures of the failures that Mr. Taylor just laid out. It's important to note that the Office of Special Counsel has corroborated our claims of retaliation and DHS's failure to comply with the law. In February of 2018, our team was in communication with a staff member of the DHS Secretary's Office regarding the roadblocks that career bureaucrats at CBP were putting in our way, slowing our progress towards the pilot and ultimately compliance with the law. At the time, the Trump administration, White House, and DOJ were pressuring DHS on full compliance with the DNA Fingerprint Act of 2005. As a result of our protected disclosures, the retaliation against me and my team by CBP leadership began. These bureaucrats immediately shut down the DNA collection pilot program and disbanded the WMD division. Further, during a conference call in April of 2018, senior officials stated that they did not want to comply with the law, despite being pressured by the Secretary of DHS and the Department of Justice. This is what led me and my colleagues to make protected disclosures to the Office of Special Counsel about DHS and CBP's failure to comply with the DNA Fingerprint Act of 2005. I continually raised a noncompliance with the law to the attention of my supervisors. They told me to keep my mouth shut and things would go easier for me. Since 2018, we have been left with no meaningful tasks or work, effectively ending our professional careers. Under the current administration, the retaliation due to our protected disclosures to OSC and Congress intensified and continues today. For example, Mr. Wynn was pressured to take a job well below his expertise and has been subject to significant reputational harm. One of the most overt and egregious actions taken against Mr. Taylor and myself occurred just over a year ago. We were stripped of our law enforcement authorities, credentials, and firearms. As a result, Mr. Taylor was also stripped of his law enforcement retirement benefits. This administration, DHS, and CBP leadership is aware of the continued retaliation. I do not believe that they will willingly take corrective actions necessary to right these wrongs. As the Office of Special Counsel wrote in a December 2021 memo, and I quote, "The agency's treatment of the complainants is particularly pernicious because it has a potential chilling effect on other agency employees, and it sends the clear message that whistleblowing will derail one's career." DHS and CBP's attitude toward us can be summed up in a recent quote from a current official. "The agency wants to bankrupt us, make us quit, die, kill ourselves, or preferably all of the above." This is the treatment we receive for coming forward as whistleblowers, simply wanting our government to follow this critical law Congress enacted. Thank you, and I look forward to answering your questions.
Senator Grassley, Senator Johnson, thank you very much for inviting me here today. My name is Kumar Kibble, and I retired from ICE after more than 24 years of federal law enforcement service, including as the agency's deputy director. Following my retirement, I worked for a company that pioneered rapid DNA technology, and I led efforts in collaboration with DHS to demonstrate how rapid DNA enables more secure borders, including determining kinship to identify fraudulent family units and to also catch human traffickers. To be clear, I stopped working at that company more than 4 years ago, and I have no financial interest or affiliation with it today. With today's roundtable, I think you've zeroed in on a border security issue that can actually be fixed. It can address one of our most significant challenges, stopping more people from coming into our country who represent known true threats. I'm looking forward to your questions, but I want to briefly put into plain English the issue that we're discussing here. Today, as you know, personnel along the border collect DNA samples from individuals in custody, stick the samples in a pouch, and mail them to the FBI's lab in Quantico. Those samples have piled up into a gigantic backlog, and by the time they're processed, the people from whom they're collected are long gone. And if those people pose a threat, the opportunity to further detain or return them is passed. It doesn't have to be like this. Instead, proven technology and processes exist that enable rapid processing of DNA samples within 90 minutes. And these samples can be processed in the field, very close to where they're collected at the border. We can and we should be getting DNA profile results while individuals are still in custody. By implementing rapid DNA testing, we provide our border officials with the necessary information to make informed decisions, ensuring that those who pose a threat are apprehended and those in genuine need of asylum are protected. Senator Johnson, you referenced the case of the 51-year-old male. I was there during the pilot in April 2019, if it's the same case, where we identified that. And that was based on rapid DNA, waiting for months for results to come back that would help us establish whether this is a fraudulent family unit would just not be effective. So the money you're spending today on DNA analysis would still be spent, but it would be spent in a way that achieves border security missions much more effectively and prevents backlogs. I'm a firm believer in this technology. I've witnessed its effectiveness. I know that if we implement it across the border, our personnel will stop far more individuals presenting human trafficking, child exploitation, national security, and public safety threats than we currently are able to stop today. In my expert opinion, this is a non-controversial border security imperative that simply accelerates the current slow and ineffective DNA collection and analysis process that's currently in place. Thank you.
I'll do my questions, and Senator Johnson will do his. We expect Rick Scott of Florida to come at a later date to ask questions as well. The three of you made protected disclosures regarding DHS and Border Patrol failures to obtain DNA from illegal immigrants at the southern border as required by the law. And based on your opening statements, the Biden-Harris administration has failed to comply with the DNA Fingerprint Act. Mr. Jones, I'd like to start with a threshold question. How do DNA profiles help DHS, CBP, and other law enforcement agencies protect our communities and at the same time secure our border?
Senator Johnson, the DNA profiles that are generated by the collection at the border allows law enforcement to then log those DNA profiles in the CODIS database. If there is a latent or a crime scene DNA sample that is in that database, then it gives law enforcement an actual lead or investigative track to be able to reopen or open a cold case. The majority of the cases in that database, 45 to 50%, are sexual assault and rape, followed closely by homicide. In our experience since 2020, we have seen very interesting and promising results that come from these DNA profiles being loaded. The oldest case that was reopened, sir, was from 1972, which was actually a sexual assault. So the value to law enforcement is immeasurable. It's in addition to fingerprints and photographs, and it gives our state, local, and tribal authorities the ability to follow up on cases. It gives victims and their families a level of closure, and it can also exonerate those that have been possibly wrongly accused.
If the Biden-Harris administration followed the law instead of flouting it, how would that have played a role in preventing the murder of Rachel Moran? For you, Mr. Jones.
Sir, as we look at the failures and successes, even at the 37% threshold that we're seeing today, in focusing on the case you referenced, we know that the subject was encountered by CBP and DHS at least 3 times. His DNA was never collected. On his 4th trip across the border, he's said to be a gotaway. He avoided DHS and CBP, Border Patrol, and was able to get into the United States. He ended up in California, and in March of last year, he was involved, according to law enforcement, in a home invasion and sexual assault of a mother and her 9-year-old child. In that encounter, law enforcement was able to collect DNA samples and sent them to CODIS. Unfortunately, there was no match because we did not collect his DNA as we should have. From March and until August, there was no investigative lead that would have led us to the subject. Do we know if we had that investigative lead and had identified the subject, we could have located him? Possibly. We know that there would have been an NCIC record placed into the federal law enforcement system that said if any state, local, or federal agency encountered this subject, he would have popped as a person of interest in the original home invasion and sexual assault of a mother and a child. He could have been apprehended. We could have had a person to look for. Do we know if we could have absolutely prevented Rachel Morin's rape and murder? We don't know that, sir. But we do know that if we were able to identify this subject earlier, he would have been on law enforcement's radar and potentially apprehended.
Also for you, the administration's DHS and CBP aren't collecting DNA at some locations at the southern border. Where, why, and what's the impact on our national security?
Sir, Senator, a colleague of ours was visiting sites along the southern border, and they went to approximately 12 sites, and neither Border Patrol nor Office of Field Operations were collecting DNA at any of those sites while they were present. They asked the officer and agents why they weren't doing it, and the response our person told us was, they're just not doing it. The impact is, again, we are allowing investigative leads to get past us, and we're frankly violating the very law that was passed by Congress in 2006 and implemented by the Department of Justice law enforcement entities in 2009. So the impact is clear.
Mr. Taylor, regarding the ongoing whistleblower court case with your colleagues, has the administration, DHS and CBP, made false or misleading statements internally or explained or public about it? If so, please explain.
Yes, Senator Grassley. When the Office of Special Counsel began investigating our allegations of whistleblower reprisal, this started back in 2018, CBP told the Office of Special Counsel that we were poor performers and were about to be fired. When the OSC pointed out that we'd received significant awards and public recognition for our outstanding work 6 weeks before the dismantling of our group, CBP then stated that we weren't a good fit in our current organizational location. When the OSC told CBP that we were reprised against and should be restored to our previous position, CBP told the OSC that the funding was no longer available. When the OSC pointed out that CBP's recently submitted budget included expanding the number of personnel in our WMD division by 500% over the next 5 years, CBP said that that money was reappropriated. A seemingly innocuous email sent by me to CBP's Finance Center confirmed that the WMD funding was indeed available and currently being utilized elsewhere by CBP, as it is today. In fact, one of our salaries, as Mr. Jones had articulated earlier, has been paid out of the WMD budget for the last six plus years, proving our point that the Office of Special Counsel has been perpetually lied to by CBP. Numerous individuals in multiple offices in CBP have made known false statements to the OSC, the Merit Systems Protection Board. They've also made known false statements to congressional oversight groups. CBP's table of offenses clearly articulates that the penalty for knowingly making a false statement in an official inquiry is removal. There are no mitigating factors, and yet no one has been disciplined. On September 23rd, Senators, you are aware, you wrote to Secretary Mayorkas and Acting Commissioner Troy Miller about CBP making false statements to the press. Your staff had confirmed with the Office of Special Counsel twice that the Office of Special Counsel had sought corrective action on our behalf. CBP made public statements to the New York Post stating, quote, the Office of Special Counsel terminated its investigation into these claims without issuing a prohibited personnel practice report or seeking corrective action. That is clearly a lie. Rather than issue a retraction, CBP stated that, quote, this is a mischaracterization of this issue based on incomplete records, and we are unable to comment further based on open litigation regarding these cases. Lie, deflect, and lie some more has been a winning strategy for CBP since 2018. They are lawless and proving to be accountable to no one. As we've mentioned to the various oversight groups we've spoken to, Senator, CBP is the equivalent of a multi-billion-dollar corporation. They have their own press corps, and they can make statements to the press regardless of how dishonest or untruthful they are. And they're given the benefit of the doubt that the average citizen would not believe that an agency would openly make a public statement that was so patently untrue. As you are aware, and your staff called CBP out on this factual and known misstatement, they continue to do so and operate in all these facets with impunity.
Okay, I'll stop and let you. You go ahead. Are you done, sir?
Yes, Senator. Thank you.
Okay, go ahead.
Thanks, Senator Grassley. Mr. Wynn, who retaliated against you, and are they still serving in government?
Thank you, Senator. There were multiple managers and staff within CBP's Office of Intelligence that retaliated against myself and us collectively. The first act of retaliation was to dismantle the WMD division within CBP's Office of Intelligence. This retaliatory act had the effect of leaving us sitting idle with absolutely no work all day. I'll just add that being iced with nothing to do is one of the most effective punishments I can think of if you want to retaliate against an employee. These acts were taken with the full knowledge of the management chain of CBP's Office of Intelligence.
So you have specific names. I can see where you don't want to, state them publicly, but we can be made aware of those names. And then I'm assuming they're still serving in DHS and within the agencies in government.
Sir, we can certainly provide you with all the names. At least two of those individuals are no longer employed by the federal government, but we can provide you with that information.
Okay. So under the Trump administration, their Office of Special Counsel were looking into this. At the start of the Biden administration, that their investigation of the retaliation just stopped?
After the Office of Special Counsel looked into the issue, the retaliatory acts did continue.
They did continue.
They did continue.
Again,
yes,
but did you have an advocate inside the Biden administration Office of Special Counsel?
No, Senator, we did not.
Okay, so that speaks volumes. Mr. Taylor, in your testimony, you said, although I cannot speak to their motives. Again, what boggles my mind is you have bureaucrats within DHS. Their job is to secure this homeland, secure our border, and yet they won't follow the law. So I'm asking you. I'll ask Mr. Taylor next, too, because you said the bureaucrats immediately shut down DNA. Why? Why would they do it? Now, again, I do understand early on with Eric Holder, there was a year where they just did not have the capability. They wanted to obtain the capability, get the funding to establish it. But that was supposed to be a 1-year exemption period, right? That was back in 2010?
Senator, that is correct. It's not lost on anyone here that this is the DNA Fingerprint Act of 2005. It was passed 19 years ago. If my memory serves me correctly, this legislation passed the House 416-4 and passed the Senate unanimously. Not that I follow all the litigation that's up. The legislation that's up here, but that's pretty unanimous and pretty nonpartisan.
It was passed in 2005, not in reaction to what was happening on the border. This is just good law that if you're going to arrest somebody, we have this marvelous technology, DNA. We ought to take DNA samples, correct? And then all of a sudden, when we had the explosion on our border, sparked by DACA, now you had another purpose, another use for it, is trying to prevent the depredations of the exploitation of our asylum law, correct?
That's certainly a reasonable inference, sir.
So again, Mr. Taylor, why would bureaucrats in DHS simply refuse to follow the law, and a law that could prevent crimes, help solve crimes, and prevent human depredations of the invasion of this country?
Senator, I wish I could answer that.
I'm asking Mr. Jones
okay.
now. I'm sorry.
Okay.
Senator Johnson, we have been asked that question by so many individuals. There has never been anyone that has overtly said to us, we don't want to do this because. I will tell you that in April of 2018, after we had been shut down, the three of us were included on a conference call with the then acting commissioner and his staff, senior leaders from Border Patrol, OFO, Field Operations, and our Chief Counsel office. The person who was the special assistant for then the acting commissioner came into the room on the conference call and said, the commissioner does not want to do this right now. He's being pressured by the secretary and by the attorney general. If we have to have a plan and DOJ pulls the nuclear card, which was then to remove any idea of the ability to not participate, there has to be a plan in place. That person left the room. We were on a phone call listening, and the first thing that came out of our chief counsel person's mouth was, if we have to do this, we will only do what's legally sufficient. One of our Border Patrol folks and OFO folks chimed in with, we can tell management it won't work. They will believe us. We can make any pilot or exercise in this fail. The real over the top for us was at the end of that banter back and forth, one of the individuals said, if we have to, we will get the press to film us forcibly taking DNA from an 89-year-old woman to garner public outrage.
So I saw that in your longer testimony, but it still begs the question, why?
It defies logic, sir. We're the largest law enforcement agency in the federal government, and we're thwarting one of the greatest tools that have been provided to us. You mentioned that the DNA Fingerprint Act of 2005 was passed when it was just the right idea. It was done in connection with the Adam Walsh Act at the same time. This was at a time we were focusing on tools that allowed us to be more efficient and effective in our law enforcement.
So one question or one reason I could think of is if it was just inordinately expensive and they simply didn't have it in their budget. So that leads me to question you, Mr. Kibble. You're expert in this. What does a rapid DNA test cost?
Senator, at the back in that time period, it was roughly $200 a test.
And that time period would be 2010?
No, around the 2000, between 2010 and 2018, 19. Recent innovations have brought that down to, like at scale, if you were deploying it fully along the border, it would drop down probably to about $100 a test.
So discuss that technology. I mean, what is a nasal swab? It's like a PCR test, or?
Sir, it's a buccal swab. It's a cheek swab. It would be incorporated into just the basic procedures that OFO and Border Patrol follow currently. It's just that instead of taking the swab and dropping it in an envelope and mailing it to join the 15-month backlog at the FBI laboratory, you would process it on site or nearby, and within 90 minutes, you'd have what's called an STR-ID, a short tandem repeat ID, which is nothing more than basically like a hyper-accurate fingerprint. Doesn't contain medical information or anything. And you're able to then make an instant, bounce it against national and international databases to see if you have any derogatory information on that subject.
So why do we have, with this technology that exists, why do we have such an enormous backlog at FBI? They just haven't updated their technology?
I can't answer that, Senator. I'm not sure. I do, with the Rapid DNA Act of 2017, the FBI established procedures to be able to ingest rapid DNA, STR-IDs from booking stations throughout the country, state and local agencies. I do know they have considered rapid DNA as a way to augment their capacity at the laboratory. I think they also are pursuing robotics to try to process about 120,000 samples a month. But the issue with all of that is you want to test it where you're collecting the DNA so the officer or the agent can make an informed decision right here and now before you let them into the country.
And again, you could have the results in 90 minutes with today's technology in terms of computerization. We could run a match on that and have the results in very short order, correct?
Very short order. And again, to the issue that you addressed before, you've got to do it locally. I mean, to get the familiar, if you're going to determine whether it's a fraudulent family unit. And DNA testing, whether it's rapid or not, is agnostic. It can determine that there is a child trafficking situation going on here, or this is an authentic family unit.
Okay, well, again, thank you. I want to thank, again, the whistleblowers for coming forward, and again, Senator Grassley for being a champion for you.
Thank you. I'm going to go to Mr. Kimmel and ask you, similar to what Senator Johnson did, but give you an opportunity to maybe give us some more information. Could rapid DNA technology be employed across our entire southern and northern border? And then in conjunction with the $100 you talked about cost, do you have any idea what it would cost on an annual basis?
Senator, I don't have the annual numbers, but you could basically project what are the candidate pool in terms of the encounters, the 2 million plus folks that are being encountered along the border, and you could extrapolate based on the $100 test cost. What would it look like? We could deploy it across the entire southern border. You could do it in phases, depending on what the budget allows. You could have a mobile capability that allows you to take a group of machines or instruments to where there are high flow areas, and you can augment, you can shift, you can be very agile in your response with the rapid DNA technology. So it doesn't have to be deployed everywhere at once, but you could strategically deploy that capability at or near the border in order to get the immediate results that we need before we release these folks within 72 hours.
Thank you for that. There was a follow-up that I wanted to do with this would be for each of you three people, and I think I know the answer, but I want to hear it from you, and it's probably just a yes or no answer. Your treatment as whistleblowers, in your opinion, has Senator Mayorkas failed to comply with the whistleblower protection laws? Mr. Wynn.
Yes, Senator, I believe he has. He has either ignored the whistleblower protection laws or his staff has shielded him from any unpleasant facts about CBP's retaliation. So that suggests an unacceptable level of either malice or dysfunction.
Mr. Taylor.
Senator, I would have to agree with that. We do know that the current Inspector General for DHS has been aware of this for, we believe, at least 5 years. We've reached out no less than a half dozen no less than a half dozen times to him. And through the work of your staff, your committee, if you go and Google CBP DNA whistleblower, I believe that we own the first 4 or 5 pages of results. We're recently on the front page of Government Executive. This is not a secret, what's going on with us or what's going on at CBP.
And Mr. Jones.
Thank you. In short, yes, sir, I do believe that the Secretary has not protected us and followed through on the Whistleblower Protection Act.
Have each of you continued to be retaliated on beyond what I said in my opening statement?
Senator, at approximately the end of 2018, I reached the limits of my ability to tolerate being iced, and I sought a separate position within Customs and Border Protection. So I can say that the retaliation against me has ceased. However, I am on a drastically different career path than I would have been.
Senator, since the removal of my law enforcement retirement, my firearm, my law enforcement credentials, the position description change, short of terminating me, there's no basically more reprisal that can be done. Just by the change of my status as a non-law enforcement officer employee has likely precluded me from participating in some of the committees and groups that we have because you're required to be a sworn law enforcement officer. So again, was there any retaliation as of recently? Again, the only further steps that could take with me besides sticking me in a broom closet or terminating me have already been done. Thank you.
Senator Grassley, I was demoted 3 levels. My career progression was removed. My reason for leaving the FBI was to come to Customs and Border Protection to help them build a counter weapons of mass destruction program. That vocation was clearly taken from me. As Mike stated, my firearm, my authorities, my credentials also stripped from me. It was in one act the final, I'll call it coup de grace, of my position and career within CBP. Looking into the future, I have no place to go. We have been with 6 years with no valid employee appraisals. We get NAs for all of our categories. So even attempting to go within government, we're being retaliated against because we can't go anywhere, because any agency will ask for your last employee appraisal as a gauge on whether you are an acceptable employee or not. So it does continue. I had someone recently say to me that they equated our existence to career terrorism, where we don't know what CBP is going to do to us next. And as Mike said, short of actual termination, we've been about as diminished as we can be and sit idle today.
Is it fair for me to assume for each of you three whistleblowers that there's never been any corrective action taken against the officials who engaged in this retaliation against you? Mr. Wynn?
Senator, that's correct. We are not aware of any such action that's been taken.
Mr. Taylor?
Senator Grassley, to the contrary, of these individuals, minus the two that have been retired, are no longer with the agency. One individual was promoted to the senior executive service. Another individual was promoted to the position of assistant commissioner. The third manager was temporarily promoted to an acting deputy executive director position. Other individuals, as Mr. Wynn had mentioned earlier, have been permitted to retire or lateral to other offices or other DHS components with no encumbrances, despite the Office of Special Counsel highlighting many of these individuals' specific acts of retaliation. They were not investigated. None of them have been investigated. When you're under investigation, you have what's called a red book, and that allegation must be either substantiated or cleared before normally, under normal circumstances, you're allowed to leave a position or go to another office. Because these people have not been investigated in any way, shape, or form, they're allowed to move about freely on their own career path or wherever they choose.
And Mr. Jones?
Yes, sir, Senator Grassley. It should not go unrecognized that from the outset, our CBP leadership has had little interest in addressing any of the malfeasance. With respect to the failures of the agency leadership, implementing the DNA Fingerprint Act law, the obstruction of the pilot, or those who have continued to actually retaliate against us. The CBP Office of Professional Responsibility was initially tasked by OSC to investigate our disclosure. At the conclusion of the OSC investigation, the special counsel stated in his letter to the President and oversight bodies on August 21st, 2019, I write this letter to inform both the President and Congressional Oversight committees of this misconduct, and it is my hope that further action can be taken to bring CBP into compliance with the law. I strongly urge Congress to continue its robust oversight efforts in this area, with a particular focus on accountability for DHS and CBP officials who have known for years that this situation existed but chose not to act. I note that a number of CBP officials central to the agency's inaction were identified by the whistleblowers but never interviewed in the investigation because CBP dismissed the extent of their involvement. Yeah. The only ones so far that have been in any way punished has been us.
Let me check on the status of Senator Scott. Is he still coming?
Yes, he is.
Yeah.
10 minutes.
I have to go at 4 o'clock, and it's our understanding that Mr. Scott will be here soon.
Yes, sir. 10 minutes.
So maybe you haven't been informed of this, so I may be informing you, but can you just stay there and take a rest? Thank you all very much.
Thank you, sir.
Thank you very much, Senator.
Thank you, Senator.
Doing well, Senator.
Thank you, each of you, for your service, and thank you for being here today. We clearly have a crisis at our southern border. It is a complete failure. I don't think anybody can deny that. America is a more dangerous place because President Biden, Border Czar, Vice President Kamala Harris, and Secretary Mayorkas have allowed criminals, drugs, terrorists, and other dangerous people into our communities all across our great country. There are real consequences to the failure to secure the border, and each victim has a name. Lincoln Riley, Rachel Morin, Jocelyn Nogari, Lisbeth Gutierrez Salazar, and her two sons, 10-year-old Juan and 7-year-old Julian. These are just a few of the many Americans killed by illegal immigrants that were released into our country by Joe Biden. Real Americans, average citizens, the ones that live a normal life, are being killed. Real American families are being torn apart by vicious crimes and deadly drugs because we have a wide open southern border, intentionally done by President Biden. As President Biden's border czar, Vice President Harris' utter failures to secure our southern border have allowed historic illegal immigration and tons of deadly fentanyl to pour into our communities and kill thousands of our fellow Americans. We also know that the federal government is an expert at wasting our taxpayer dollars. I want to thank each of you for being here today, for your courage to speak up in an effort to improve our federal government. I introduced the Stop Human Trafficking of Unaccompanied Migrant Children Act, which addresses the unbelievable reports of unaccompanied migrant children being released to sponsors under this administration who have not received proper screening from the Department of Health and Human Services. You can't imagine they're doing this. This bill will ensure extensive vetting by DHS and HHS before a vulnerable, unaccompanied child is placed with a sponsor. A 2023 report from the New York Times, which is not known for being unfriendly to the Biden administration, stated that during the first 2 years of Biden's presidency, his administration could not reach more than 85,000 children. That's unacceptable. Mr. Jones and Mr. Taylor, I have a few questions for each of you. Do you believe DNA tests of illegal aliens should be administered before pre-release and as part of the process when HHS places an unaccompanied migrant child with a prospective relative sponsor?
Senator Scott, the DNA tool is invaluable, especially when establishing the family units. So the short answer is yes, sir.
Okay. Mr. Taylor?
Concur, absolutely, Senator. Yes.
Yep. Can you please talk about the importance for testing the DNA of illegal aliens and criminals at our borders as it refers to matching it with prior crimes committed in the U.S.? Any of you?
Senator Scott, the DNA Fingerprint Act is a valuable tool that was enacted back in 2006. And it allows us to look at the latent or crimes that are currently unsolved, cold cases, and match them against known identities. So when we're collecting at the border and adding those known identities and then immediately matching them to open criminality, it's an outstanding tool for law enforcement. One of the things we found since 2020 is that in the matches that we have actually seen, and in 2023, sir, there were 1,037 matches due to the DHS collection, even at 37%. We actually found a cold case and reopened it from 1972, sir. The ability to give closure to families, reassurance to victims, and to actually exonerate those who are wrongly accused is something that the DNA Fingerprint Act gives us the ability to do. And by only 37% compliance, there is some progress, but we believe it's linear. So if that's the case, we likely missed over 1,600 violent criminals in 2023 alone.
Mr. Taylor?
Yes, Senator. If to Mr. Jones' point, he is correct. We believe these statistics are linear. At a 37% compliance rate last year, there were still, not including the gotaways and the other unknowns, which we do not know, there were still almost 2 million people that we did not collect their DNA from. that we processed at the border. Though this is slowly an improvement. In 2017, CBP, ICE, and DHS, we were collecting DNA from about 3% of people that we encountered. There were a lot of reasons, misinformation reporting up. The thought for that low level at the time was CBP argued that DNA was being collected downstream and they were being turned over to U.S. Marshals or possibly other law enforcement entities. That was not the case. But to just answer, the short answer to your question is absolutely. It's inarguable. One thing, help me out if I misspeak here. I believe at even a 37% compliance rate, CBP is responsible for about 40%, 42% of the annual cases that are being solved through the entire FBI CODIS index. So we're one law enforcement agency. Granted, CBP's one of the largest law enforcement agencies, or the largest in the country, but one agency's solving 40%, or presumptively solving or opening 40% of the cases resident out of the X millions in the FBI CODIS DNA, FBI CODIS index. Right along those lines, too, what's even more interesting is I believe CODIS was first operational in 1997, and we've just started effectively giving them a fair amount of samples less than 4 years ago. So if we're solving almost 40% of the annual cases that are being presumptively clued in every year, imagine what we would be doing, at a 90 or 95% rate.
Yeah. Mr. Wynn?
Senator, if I can just kind of put some numbers behind what Mike and Mark have just said. I want to share some numbers with you that apply to simply CODIS hits on DNA samples that were collected just by Customs and Border Protection in FY24. So just from October 2023 to June 2024, DNA samples submitted to CODIS by Customs and Border Protection have hit on 10 homicides, 145 forcible sex offenses, 97 instances of larceny, burglary, robbery, or embezzlement, and 10 assaults. So that is just a sample at less than 100% compliance. So I just ask you to imagine if we were at full compliance, the number of cold cases and crimes that we would be helping to solve.
Why aren't they doing it?
Senator, we've speculated on that question numerous occasions, and I can't give you an answer that I would call definitive. I can speculate, but to me and to us, it's a no-brainer. We should be putting more effort into getting us closer to 100% compliance every day.
So do you think it's a directive from senior leadership?
Again,
you don't know.
I could only speculate.
Anybody else?
Senator, as was articulated earlier, there were some CBP employees that recently went down to the southern border, and they had visited approximately 12 different stations or offices that were processing migrants. And they noted that DNA was not being collected at any of those facilities. So you asked the question, is this being directed by executive management? For something that's a requirement from law that's part of the booking process, that sort of thing, I cannot believe, I don't think a reasonable person would believe that has not been okayed somewhere up the food chain. It would almost be akin to continually question someone after you arrest them to not reading their Miranda rights or not taking their fingerprints. It's part of the booking process now. It's codified in the law, particularly from the clarification that then Attorney General Barr did in early 2020 that DHS will collect DNA from those non-U.S. persons detained under United States law. This is not this isn't a you may or you can if you would like. It's a you shall. And the fact that it's not being done with clearly no repercussions could lead one to reasonably deduce that this non-compliance is sanctioned at a high level.
Could DNA testing at the border have prevented any of the horrific murders by the illegal aliens we have witnessed under the Biden administration?
Senator, obviously we cannot say so with certainty, but at a minimum, every collection of DNA represents a potential new investigative lead that could lead to the solving of many of the outstanding crimes.
Okay. If DNA would have been collected from illegal aliens entering our country, would it have prevented potential attacks like the attempted breach of the Marine Corps base Quantico by Jordanian nationals in the U.S. Illegally?
Senator Scott, that is another one that's hard to say, because unless there was an open case of DNA, latent DNA that would have been matched to that subject, those individuals would have had their profiles logged, but they would have not come up as an active or an open situation. Mm-hmm. If I may step back, you asked about, you'd mentioned the Morin case earlier. Mm-hmm. What we do know about that case is that we as CBP had the immigrant in custody 3 times, never collected his DNA. He became, on his 4th entry, a got-away and got past CBP and Border Patrol. We know that in March of last year, he was involved in a home invasion and a rape of a mother and her 9-year-old child. DNA was taken at that crime scene and submitted to CODIS. There was no match because we did not take that DNA. Between March and August, this individual was free to roam about the United States when Rachel Morin was raped and murdered. Do we know that if we had had that initial hit that we should have gotten, we could have stopped him? We don't. But we do know that law enforcement would have had a name, a photograph, and fingerprints of who to look for. And over that period from March to August, if he had been stopped by state and local, if he had been encountered by other federal officials, that record would have been an NCIC, and he would have been detained as a person of interest in that home invasion and rape of the mother and child. So it works, sir. Is it going to stop things? Logically, we think so. We believe so. We can't tell you for sure, but I would bet my paycheck that they will most certainly prevent other criminality when we're able to identify someone who has already committed criminal acts.
So, we all have families, right? So what do you think the purpose is that they want to open the borders and not make sure criminals aren't coming across? They have to have, the people who are making these decisions have to have families too. Why do you think they don't care?
Senator, you actually have us at a loss for words also. We can't figure it out. We have families, as you said. When we first got involved in this project, when it was originally assigned to us by our then commissioner, we started the research and we worked with the FBI and the Bureau of Prisons and started looking at what the success stories were. And they motivated us because it was individuals that we had encountered multiple times and had never taken their DNA, and they went to do horrible acts, rapes and murders. And each time we had a success story, it motivated us. It was, we were able to now detect this person who is in our country that is and has committed criminal acts, and we're now able to interdict them because of this law and this process. So why? No, sir, I have no idea why.
Okay. Well, first off, thank you for being willing to speak up. And I hope you're being treated fairly. So I don't know if you want to talk about that.
Senator Scott, Senator Grassley has been a champion for us in the whistleblower retaliation piece.
Yeah.
Our retaliation started in earnest in February of 2018 when the 3 of us were removed from our positions in one day. I was removed as a director of the WMD division. Mr. Taylor was my deputy, and Fred was part of our team. The division was disbanded, and since then, we have sat without a counter WMD division within Customs and Border Protection. That, to me, is also another vulnerability that has been created because we've been retaliated against for coming forward and bringing this to the attention of our leadership.
I just don't get it. I just don't understand why people don't want to secure our country. It doesn't make sense. Yes, sir.
Senator Scott, if the initial attorney that wrote the initial disclosure about CBP's DNA non-compliance with collecting DNA, Very, very sharp gentleman. Unfortunately, he has left federal service. But it took us an hour and a half to explain to him, because he couldn't, when we were first explaining our disclosure, because it was absolutely not plausible to him.
Right.
He just kept saying, this is the dumbest thing I've ever heard. This absolutely does not make sense.
Right.
And as we started showing, we provided him all the background information for the law. We provided statistics from the FBI. We provided statistics from CBP's own website. This is how many encounters we had. We had 600,000 encounters. The whole agency sent in 304 DNA samples, and we presume most of those came from our JTTF task force guys that were working with the Bureau. We've heard theories of this noncompliance of that, the fact that Attorney General Barr changed the law in March 2020 and gave the Attorney General the absolute authority to order DHS to do so. There's been speculation that, they're not bigger than us. Nobody's going to tell us what to do. That does not explain what had transpired in the decade beforehand. But to your point, and I wish it was, I think one of the greatest impressions we made on the individual, the investigator, the Office of Special Counsel that wrote the original disclosure report, was he could not get over he said he could put no logic to it. And he was quite an analytical individual. And he just said it did not make sense when he explained it to then Special Counsel Henry Kerner either. It said, to your point, this is an absolute no-brainer.
Right.
That the technology we were going to speak to earlier did not come down to. The FBI has streamlined the process. It adds about 30 seconds to the booking process to swab DNA, to tie that particular swab to the with a barcode you can shoot with a gun that's automatically tied to the prints in the person's profile. The backlog, according to the FBI, according to last week, is all but non-existent anymore. And even if they don't get results for 2 to 5 days, to Mark's previous point, if this person is already out of custody, at least their DNA profile is linked to their arrest profile, their interdiction profile, just like their fingerprints are, just like their photograph is. And a great example that came up before, the recent New York machete case, where the individual, the gentleman's name was Christian Nganlangi. This was a case in New York City, you may be familiar. He tied up the young man and the young lady and raped the young girl. He committed this crime on June 13th in 2024. DNA was collected from the young lady through the victim kit. He was identified immediately because a DNA sample was taken by immigration officials 3 years prior to that. He was on the lam. The gentleman was arrested 5 days later. And when they caught him, it was in the news. Apparently he was hiding under a vehicle. So there was an example of, in a very short period of time, we know who this guy is. We know he's here in New York, and we're going to find him. So again, we understand there are a lot of political things I'd mentioned before. Your rival here today, that this passed the House 416-4 and passed unanimously in the Senate. This is probably one of the least partisan pieces of legislation in the last 100 years. I don't follow all that, but we've seldom see such agreement that this is really a good idea. And right. Somehow we're not doing it. And to your point, it is absolutely inexplicable.
All right. Well, thanks for what each of you are doing. And you're right, Senator Grassley does a great job working with whistleblowers and taking tough issues and trying to make something good happen. He does a great job. So thank you for being here.
Thank you very much.
Thank you, sir.
Thank you.